Welcome to Business Legal Lifecycle TV, the live TV show all about the legal aspects of your business to help educate you on complex legal terms in an easy to understand manner, to help understand why you need to do certain things in your business from a legal point of view, and to help you develop a plan for the future. Our mission at Business Legal Lifecycle is to help empower all small to medium-sized businesses around the world to get access to legal advice so that they can help build their communities and make the world a better place.
Hi everyone, and welcome to Business Legal Lifecycle TV. Today is our legal updater show, where we go through a number of legal updates across Australia and across the world, and the legal changes that have happened that is relevant to our listeners and to our viewers. I am Craig Mason, and I have with me, as always, Jeremy. Say hello to everyone, please. Jeremy.
Hello everyone, hope you're having a great Friday.
Yeah, absolutely. Friday, and we're getting very close to the end of the year. All right, so changes around the world. What do we got today? Royal Commission's done something, have they?
Yeah, well, no, the Royal Commission's been called. So it's been announced in the wake of questions about a barrister informant in Victoria. Anyone who's probably in the legal profession probably knows about this, but there was some explosive news that was delivered recently after the High Court of Australia lifted a suppression order involving the Victorian police and a barrister from Victoria. So the barrister's name hasn't been released as at the time of recording this, but she's known as, and we know it's a she, as EF. And while she was purporting to act as a barrister for certain convicted people related to Melbourne's gangland wars, she provided information about those people to Victorian police. So this has serious ramifications because a lot of people were convicted, involving information that she provided. The High Court basically found that information there was no real good reason for it to be suppressed. There's various reasons. I'm not going to go into all those reasons, but basically that EF's actions in purporting to act as counsel for convicted persons while covertly informing against them, the High Court found was a fundamental and appalling breach of EF's obligations as a barrister to her clients and also her duties to the court. So this is a pretty serious case. There's going to be some serious ramifications from this. Apparently there are some 600 cases has been reported as being involving information that was provided as part of this informant. So all of those are probably going to have to be reopened. The Victorian Premier, Daniel Andrews, announced the Royal Commission to look into it. And so it'll be really interesting to see what actually comes of that. But barristers and solicitors, we have higher obligations to courts and to our clients in a lot of situations. So, whilst people shouldn't question their barrister and solicitor, just be wary of it. And the barristers and solicitors out there need to be aware of what the consequences are because, despite their best efforts of the police and this barrister, the fact that this happened hasn't been suppressed and is now out in the public domain. So, Craig, that's the first one. Do you want to go into encryption laws? Yeah, absolutely. I think watch this space on the one you just spoke about there. That's going to be ongoing for a long time. So, interesting to see what happens there. So the federal government, in relation to encryption laws and passing of some new legislation. So, this will allow security agencies in Australia to gain greater access to encrypted messages. This is after the major parties here in Australia agreed to pass some legislation on the final sitting day of Parliament in 2018. So essentially the legislation allows for law enforcement and some government agencies to ask for three different levels of assistance from technology companies in assessing encrypted messages. So there apparently is a three-tiered approach, includes technical assistance request, technical assistance notice, and technical capability notice. This is explained in CNET. Technical assistance request, is a notice to provide voluntary assistance to law enforcement, the safeguarding of national security and the enforcement of the law. So there'll be some pushback on those, given they're voluntary, no doubt. The next one's a technical assistance notice as opposed to the request. And this is a notice requiring the tech company to offer decryption they are already capable of providing that is reasonable, proportionate,
practicable and technically feasible, where the company already has the existing means to decrypt the communications. And the last one, which is a technical capability notice, is a notice issued by the Attorney General requiring tech companies to build a new capability to decrypt communications for law enforcement. The bill stipulates this can't include capabilities that remove electronic protection, such as encryption. So what does all this mean? Basically that Australian government officials have been cautious of using the word backdoor, but tech companies, worry that the law is essentially a pathway for such tools. So it does seem quite complicated with the different technical assistance and technical capability notices, and sort of the normal legislation where it requires lawyers to sort of test these sorts of things. But I would say that there's going to be a fair bit of pushback from the tech companies based on what's out there at the moment. So yeah, interesting to know that the government's passed that with the help of the other parties, and there's going to be a number of other things in this area about the request for notices and the capability notice. So yeah, interesting new development. I think it's all about national security, obviously, but it'll get slipped in there with the rest of it, which is the enforcement of the law. So it'll come under a number of other different areas as well. All right, so number 3, slavery.
The third one, we've actually talked about this before, but about the modern slavery laws, and we talked about it it hadn't yet passed Parliament, but that has passed now. So under these new laws, entities with an annual consolidated revenue of more than $100 million will be required to report on slavery risks in their supply chains. So what that means is, if you're getting clothing manufactured overseas, and there's an argument that clothing was made by someone and slavery is in that supply chain somehow, or even the supply of tea, that businesses in Australia need to be really careful on this and figure out, make sure that they're not supplying goods really goods, not services, but goods that are, that have come from slavery. So that law has now passed, and it's really important to be aware of these changes. They may not affect you, but it's the kind of thing that, as it rolls out for the companies over $100 million, it will start to come into smaller and medium-sized businesses. And it's probably a good practice to think about anyway. Like, where is our stuff coming from? Where is what we generate? Who's generating that, and who's making the money, and is it being supplied properly, and no slavery in place? So I think that's all really important, and I think that it's something to be aware of, and something for all small to medium-sized businesses to think about. By definition, they don't have a revenue of over $100 million, but it's still important to know those things. So that's the 3 main changes that we had. Craig, do you want us to kick off with the news from ESIC and the ACCC?
Yeah, absolutely. So a former company director, Mr. John Falconer, was recently sentenced to 4.5 years imprisonment with a minimum of 3 years to serve. He pled guilty in the Supreme Court in New South Wales in relation to 5 counts of dishonest conduct and 1 count of giving false or misleading information to the ASX. Essentially, he made illegal payments from a company account for about 2 years to the value of $6.25 million. So he is at this stage going to prison. So the next one was what? ASIC, I think.
Yeah, the next one is ASIC, and that's about UBS Security has paid a $120,000 infringement notice based on a breach of the Market Disciplinary Panel rules about the ASIC market integrity rules. So the conduct related to 6 on-the-market buyback of shares conducted by UBS that was in breach of the ASIC market integrity rules. And basically, ASIC's they only charged them $120,000 because the breaches were related to accidents. It was careless. It wasn't, and there were no internal controls. It wasn't deliberate. So ASIC didn't throw the whole book at them, finding them millions of dollars, but $120,000 for breaching the ASIC market integrity rules. Craig, the next one's one of our unfair contract term ones.
Yeah, so if you listen to some of the previous shows recently, 158 and 150 something, where we were talking about unfair contract terms and the importance of those that have come in Australia, at least in 2016. Recently, Visi Recycling, Cleanaway and Suarez Recycling reviewed and amended potentially unfair contract terms in their standard form contracts. And this is following an ACCC investigation. The changes relate to their price variation and liquidated damages clauses that previously allowed them to unilaterally increase their prices in specified circumstances and impose penalties on customers who wanted to exit their contracts before the end of the contract term. So as we said in the previous shows, it's something that hasn't necessarily had much case law about it, but there are things like what this one is about, where companies are making changes to things because it's likely to be considered unfair, rather than continuing on with contracts that may have issues in them. They're making these changes now through the ACCC investigation. So that's Visi Recycling, Cleanaway and Suarez Recycling. I think it's Suarez Recycling. And those sorts of industries. So if you're in those and you've got any contracts with them, you're probably going to get an amended one that's going to have some watered down clauses in it. So there'll be plenty more of these coming out, I would say. Yep. So over to you, Jeremy, for the last. The
last one, and we reported on this earlier that Westpac and ASIC had reached a settlement over Westpac's breach of responsible lending laws, and Westpac and the ASIC had agreed to a $35 million settlement. However, that needed to be run by a judge, and a judge needed to approve it, and a judge has actually rejected that settlement offer and making the parties go back to try and have another go at either resolving it or going to court. And the reason that the judge found that, I found this curious, was that there was an admirable ingenuity had been applied by ASIC and Westpac's lawyers to gloss over the very real differences which exist between them on the interpretation of the part of the National Consumer Protection Act that the ASIC proposed Westpac breached. So the judge found that because he didn't think that the parties were being genuine and they didn't actually agree on what was wrong, that he wouldn't endorse the settlement, and so told them to go away and have a bit more of a chat about it, which I thought was a really interesting discussion, because the courts are all about not having cases heard, and here's a judge where parties have come to a settlement and not agreeing. The judge isn't agreeing to actually resolve it. So we'll be definitely keeping an eye on that one and seeing what happens, and then we'll report back once a resolution is reached or it goes to trial.
Yeah, definitely interesting that they've stepped in, but probably a good thing. Alrighty, excellent. So that's it for today's show. This is show 159. So if you're interested in the notes, go to the website, show 159. And now, so this is our legal updated show that we do once a month, where we go through, as we've done today, some changes around Australia and the world. If you've got something that you've seen over the next month or so that you think everyone else might be interested in hearing about, please get in touch with us and send us the info, and we'll check it out and incorporate it into the show. We are always willing to tailor these types of shows to our viewers or listeners and make sure they're getting the most value out of it. So if you do have some changes that perhaps we aren't aware of, or that is specific to your industry, please let us know and we'll add them to the show. If you've got any other questions about anything else that we've covered, please also let us know. Happy to help where we can. So, Jeremy, anything else you want to talk about today?
No, I think that's great. We'll be back on Monday for our next Fast Fix Monday, and I hope everyone has a great weekend.
Great. Thanks, everyone. See you later.
Bye.